Hello. So, in this lecture, I'm going to discuss Doris Buss's article, which is on the syllabus. And Buss discusses intersectionality and international tribunals regarding rape in the context of war. So, the lecture will deal with sensitive topics such as sexual violence and ethnic cleansing and war. If you find this difficult to listen to or consider, then please do not watch the lecture. I hope that you're doing well. So the article for this week looks at international tribunals that prosecute crimes of sexual violence and rape in Yugoslavia and Rwanda. So, Buss focuses on the prosecution of mass wartime rape as crimes against humanity by the Rwanda and Yugoslav tribunals. She is particularly interested in how the tribunals interpret large-scale gender-based violence and its role in the construction of ethnic identities. She analyzes one decision of the Rwanda tribunal in depth, the prosecution of Sylvester Gakambitsi for the rape and murder of Tutsi women in Rusumo, eastern Rwanda in 1994. In this judgment, the tribunal held that the rape of a Hutu woman married to a Tutsi man was an attack on the Tutsi community and therefore a crime against humanity. And in doing so, it concluded that the rape targeted not her but her husband. This decision, as Buss points out, depicted rape in a superficial manner, failing to address the intersections of gender and ethnicity that enabled rape to take place, and disconnected it from everyday violence against women. Buss advocates instead an interpretation that acknowledges the structural basis of sexual violence within societies and the intersectional dynamics of oppression affecting racialized women in conflict situations. In turn, her contribution provides a nuanced root in the formations of ethnicity that are produced through state and institutional practices, specifically in relation to women and women's bodies. So, what Buss argues in the article is that rather than thinking about rape as a crime against a woman's body, and a specific type of woman who has experienced intersectional forms of sexual violence because of not only gender, but ethnicity, religion, and class. Many who are involved in the prosecution of rape and wartime rape analyze these crimes only in relation to crimes against an ethnic group. And so rape itself is counted as one of many crimes during war, without it being understood that this is a crime against a woman. And in many contexts, as in my own research in India, what I would argue is that it is precisely the sexism and heterosexism and misogyny and sex phobia of the ethnic group that has actually facilitated rape, including rape from another ethnic group. So rather than seeing rape as a crime against the honor of a supposed certain caste or class or ethnic group, what I would argue is that it is the sexism of this ethnic group that has allowed for these women to be victims of persecution and victims of sexual persecution. So these women are not protected by their ethnic group. And because they are not women who are affluent women, they are not protected as women would be from an affluent ethnic group. So this is a clip of Doris Buss.
Hi, I'm Doris Buss in the Department of Law and Legal Studies at Carleton University. I've been thinking a lot about mining and human rights lately, and more specifically, women's rights. And the connection between those might not seem obvious at first glance. It certainly wasn't on my research agenda until I started working in collaboration with a fabulous non-governmental organization here in Ottawa and with really bright colleagues in other departments at Carleton and in universities in Kenya, Sierra Leone, and Mozambique. We've come together as a group because we were all interested in looking at the role of law in addressing sexual and gender-based violence and armed conflict. And in the course of that work, we began to look a bit more closely at resource extraction and sexual and gender-based violence. And that started a decade and more research collaboration. Certainly, one of the starting places for us in that work was sexual violence and exploitation. But in looking deeper at the relationship between human rights and mining, we started to unveil a much more complicated story. We found that women in sub-Saharan Africa work in mining in large numbers. Some of them work in industrial forms of mining, the kinds of mining enterprises that you might associate with Northern Ontario or Northern Alberta. But more commonly, they work in small-scale mining, which is a form of mining that's done using more basic tools and at a smaller scale. And we discovered that women working in mining earn much more money from that livelihood than they do from farming. And they pay for their school fees, their children's school fees, and they feed their children with that money. And the story of the human rights dimensions linked to mining starts to look a lot more complicated. One thing we discovered is that small scale mining is not that small when we look at the large numbers of people who work in it and rely on it for their livelihoods. And when we look at the place of this form of mining in larger global mineral economies, it was a surprise to me to find a large number of international and transnational laws, policies, and human rights developments, all aimed at addressing some of the harms linked to mining, particularly in sub-Saharan Africa. Harms such as the links between armed conflict and mining, child labor, widespread sexual violence, land appropriation, as just a few examples. In our research, we track both how women in mining may experience and strategize around human rights and exploitation. But we also study the international human rights and mining legal developments themselves to consider how assumptions about women and mining inform or not the directions these policies take and their consequent impact on the women in the mining areas that we study. In the course of doing this research, I've been reflecting on how lucky I've been in doing this work, how fortunate I've been to forge collaborations and connections with non-governmental organizations, with super bright activists, with fabulous colleagues around the world. And those are the kinds of connections and collaborations that I see really valued and supported here at Carleton in the Department of Law and Legal Studies and at the Faculty of Public and Global Affairs.
So that is a clip of Doris Buss discussing international politics and human rights. And I will discuss international human rights in relation to Doris Buss's very interesting and important article regarding intersectionality in the context of war. And I will talk about wartime rape and crimes of honor, intersectionality and sexual violence, prosecutor versus Gagambitsi, rape and international laws. Since the early 1990s and the wars in Yugoslavia, wartime rape has become arguably as a matter of necessity a feminist preoccupation. In the face of increasingly stark reports of extreme sexual violence against women in armed conflicts across the globe, feminists and other human rights activists have been working to secure greater international condemnation and prevention of violence against women. In both Rwanda and Yugoslavia, the mass rapes of women took place within conflicts variously described as nationalist in the context of Yugoslavia and/or ethnic for both Yugoslavia and Rwanda, in which sexual violence was depicted as a way for one group to harm the other. That is, particular groups of women were subject to mass sexual violence because of their deemed ethnic identity. But unraveling the intersection of gender and nationalism, or more often ethnicity, was not straightforward. In the early stages of the Yugoslav conflict, feminist legal activists and scholars highlighted concerns with how and if to bring an intersectional understanding of mass rape to international legal action on mass rape. So, this sexual violence against different ethnic groups is only really considered as harm done to an ethnic group. And even in to be more obvious, the only rights that are considered are the rights of husbands and fathers. And so when women experience sexual violence, many uh, mainstream commentators and even lawmakers who are responsible for discussing these different ethnic groups think about the violence done to this ethnic group and the honor of a husband and a father rather than the violence done against an individual person. So the problem really is a legal problem that these international tribunals and these kind of ethnic groups are trying to protect themselves in the context of war. However, individual people, including individual women, have the right to bodily integrity, they have the right to make their own money, and they have the right to be people who are free both from war but also from an ethnic group. So, Bus writes, I'm interested in how the phenomenon of mass rape against women, particularly in Rwanda, is narrated by the tribunal in its decisions. In particular, I want to consider how the tribunal describes the relationship between sexual violence against women and or ethnic conflict, against women and ethnic conflict. I argue here that the tribunal's approach to the confluence of gender and ethnicity minimizes rather than opens up the complexity of large-scale sexual violence. The existing international legal provisions on war crimes and crimes against humanity largely failed to treat wartime rape as a serious violation. And where rape was recognized, it was defined narrowly as an attack on a woman's honor. So, in the research I've done in India and about India, what I've found is that an obsession with men, which causes India to have the largest rate of female infanticide in the world, often means that people can only sympathize with victims of rape if they sympathize with their fathers or their husbands. So, the kind of sickening irony is that no one really cares about crimes against women, they do care about men's lives. For feminists, the weak legal provisions in place raise the possibility that rape would be either treated as a minimal crime or, as was the case in the two world wars, completely overlooked since the initial public outcry and condemnation receded. So the refusal to legalize gay marriage in India and the refusal to recognize violence against transgender people and queer people, including lesbians, in the media and these highly publicized kind of cases of sexual violence against upper caste Hindu women are obviously about crimes against a woman's honor, and a woman's honor is protected by a certain caste and class of men. The problem with sexual violence in the context of world wars is that so much attention is given to these really large-scale horrific crimes against an ethnic minority, and these constant efforts to cleanse an ethnic minority are obviously so horrific in scale and in nature that they gain a great deal of attention in the law. And crimes like sexual violence, pedophilia, harassment and stalking of women in the context of war, including the global war on terror, are often not taken as seriously as these crimes of ethnic cleansing. So this is a clip from the United Nations discussing sexual violence in the context of war.
Has been more than courageous in many fronts. And I believe that one of those fronts is the serious and diligent attention that's paid to questions of sexual violence and crimes of sexual violence. There's been more jurisprudence out of our tribunal in 5 years than in the past 500 years from international criminal courts. Until the ICTY, until rape was listed as a crime against humanity, it had been ignored in all international instruments. What the tribunal has done, I believe, first just by listing rape as a crime against humanity, but secondly by prosecuting it and by developing the jurisprudence of sexual violence, is that the leaders of these conflicts are now put on notice that the rules have changed. That's an important development. It's the development that has been picked up by the ICC, and now you can't imagine an international tribunal or a mixed tribunal without sexual violence being prosecuted. And we're talking about sexual violence that occurred during the armed conflict in Yugoslavia, but that might have been committed against men and women. It's a weapon. It's because it goes to the very psyche of the person. It goes to a physical sense of the person. It goes to a social sense of the person. Zgazio mi je ponos. Više ne mogu nikad sebi da dođem, da budem žena kao što sam bila. It's a very adequate manner in which the person somehow feels that they've experienced a death and yet are condemned to continue to live. They came, they were very willing, and even during the time that we were giving evidence, that they were determined to tell the truth because they wanted justice to take its course. The courtroom opportunity gave them an opportunity also to look at their assailants in the eye. So we did have some courageous witnesses. On je, pošto je završio, mislim na silovanje, što je znači završio silovanje, sjeo je i zapalio cigaretu. Rekao je da bi on možda mogao i više, mnogo toga više. Međutim, da sam otprilike višnjaknu njegove čerke, a za sada neće. I believe the women have contributed to reconciliation. Now, whether it's a conviction for rape, what that adds, I think that it gives a strength to the women who've testified, a vindication of their suffering. I know that it gave incredible strength to women all over the world. I share with witnesses in saying it is my hope that there will be differences in the way war is waged because of witnesses testifying before this tribunal. I don't know that yet. They don't know that yet. But one of the driving motivations that brings witnesses these difficult steps to talk to this tribunal is their hope that if they do this now, then nobody or people in the future won't have to suffer like they've suffered. It's a watershed in international criminal law. The tribunal has been more than courageous in many fronts. And I believe that one of those fronts is the serious and diligent attention is paid to questions of sexual violence and crimes of sexual violence. There's been more jurisprudence out of our tribunal in 5 years than in the past 500 years from international criminal courts. Until the ICTY, until rape was listed as a crime against humanity, it had been ignored in all international instruments. What the tribunal has done, I believe, first just by listing rape as a crime against humanity, but secondly by prosecuting it and by developing the jurisprudence of sexual violence, is that the leaders of these conflicts are now put on notice that the rules have changed. That's an important development. It's the development that has been picked up by the ICC, and now you can't imagine an international tribunal or a mixed tribunal without sexual violence being prosecuted. And we're talking about sexual violence that occurred during the armed conflict in Yugoslavia, but that might have been committed against men and women. It's a weapon. It's because it goes to the very psyche of the person. It goes to a physical sense of the person. It goes to a social sense of the person. Zgazio mi je ponos. Više ne mogu nikad sebi da dođem, da budem žena kao što sam bila. It's a very adequate manner in which the person somehow feels that they've experienced a death and yet are condemned to continue to live. They came, they were very willing, and even during the time that we were giving evidence, that we were determined to tell the truth because they wanted justice to take its course. The courtroom opportunity gave them an opportunity also to look at their assailants in the eye. So we did have some courageous witnesses. On je, pošto je završio, mislim na silovanje, što znači završio silovanje, sjeo je i zapalio cigaretu. Rekao je da bi on možda mogao i više, mnogo toga više. Međutim, da sam otprilike još nekima njegove čerke, za sada neće. I believe the women have contributed to reconciliation. Now, whether it's a conviction for rape, what that adds, I think that it gives a strength to the women who've testified, a vindication of their suffering. I know that it gave incredible strength to women all over the world.
Okay, I'll stop the clip there and go on with the lecture. The point that Buss's article makes is that intersectionality, the concept we discussed from Kimberly Williams Crenshaw, is useful in international contexts. So intersectionality offered a method for examining how individuals and groups were positioned within matrices of domination. Kimberly Crenshaw's work, for example, Crenshaw's 1991 article, examined the intersection of gender and race in U.S. legal responses to violence against women. She traced how the convergence of gender and race produced particular notions of black and white, male and female sexuality in the context of U.S. history. The dangerous black male rapist, for example, materializes against the vulnerable white female complainant. Black women's sexuality, culturally understood as lascivious, marks the Black woman as always a legitimate rape victim against the idealized white female victim. So Buss is interested in how this intersection of race and gender and class is applicable to contexts of war, such as in Rwanda and Yugoslavia. And she is interested in the ways that sexual violence against certain women serves to mark an ongoing contestation between different groups. And we can see this in cases of sexual violence against Indigenous women and girls, including sterilization of Indigenous women, which we've discussed in previous lectures. That this kind of eugenics is part of a certain racist biopolitics that favors one ethnic group over another. And it is often women who are part of a certain ethnic group that are subject to extreme forms of violence, including sexual violence, sterilization, and murder. The problem is, though, that when obviously tribunals understand this violence, they understand the violence in relation to this ethnic violence, which is a eugenic program to, say, prevent an ethnic community from reproducing or from even existing in the world, which is eugenics in its most extreme. It is a program of Nazi extermination that happened in the Second World War. However, the sexual violence against women who are part of an ethnic community is still sexual violence. It is not the same as other acts of violence. And what I would argue in relation to my own research about caste and class and sexual violence in India is that the sexism and the heterosexism and the preference for male children among all ethnic groups in India is what still facilitates the specific sexual violence against women of any ethnic group. So, Buss writes, I consider some of the implications both for international criminal prosecutions and feminist advocacy of an approach to intersectionality that considers the multiple ways in which gender violence is constitutive of, rather than simply resulting from group identities. How does law narrate and understand ethnic violence without, at the same time, treating social distinctions such as the ethnic group as an empirical reality? How do feminists tell the stories of women's suffering through the lens of ethnic cleansing without accepting as truths and reproducing the very logic of the ethnic contours of the conflict? How do we, in effect, account for the instability, fluidity, and contested nature of the social groupings that we see as intersecting and co-constituting? So the third point, we'll look at this case, prosecutor versus Gakambitsi. So the decision in Gakambutsi for Bus is unsettling. While sexual violence against women is prosecuted in this case and the defendant is ultimately held responsible for 8 rapes, sexual violence against women is at the same time depicted in a strangely superficial manner. In this respect, Gakambutsi appears to realize some of the feminist concerns outlined earlier, that the egregious mass rape of women in Yugoslavia and later Rwanda would be seen as disconnected from everyday violence against women, and an understanding of sexual violence at the intersection of ethnicity and gender minimizes the gendered phenomenon of violence against women in wartime. When read in its entirety, the Gakambutsi decision maps the ways in which gender violence, when placed in the frame of ethnic conflict, becomes difficult to see as a complex social problem. I want to suggest that the problems of Gakambutsi reveals that the problems Gakambutsi reveals are not just about the limits of law and addressing the complexity of social ills like violence against women. Rather, Gakambutsi is important in demonstrating how, in this case, legal decisions presume rather than interrogate the processes by which conflict is seen to be ethnic and violence becomes sexual. The Rwanda Tribunal offers a narrative in which sexual violence is depicted as almost the inevitable outcome of ethnic conflict rather than considering the mechanisms by which a genocide might be enacted through particular modalities of violence and particular types of sexual violence. So, what is interesting is this phrase that Buss uses, legal decisions presume rather than interrogate the processes by which conflict is deemed to be ethnic and violence becomes sexual. So what is interesting for Buss to consider, and I think it's a really excellent point in the article, is it possible that it is only through rape forced marriage, child sexual abuse, that an ethnic group is even formed as a distinct ethnic group. So, in the case of India and the research I've done regarding India, caste and caste endogamy is a term that is used to refer to the ways that different castes of people exclude others by only marrying within a certain lineage of caste. So it is essentially then not necessarily always the case that someone consents to a caste-based marriage. And so perhaps it is only because of these kind of coercive practices of rape and sexual uh, and presumed heterosexuality and forced marriage that this ethnic group or caste remains pure. And this is also true in the history of slavery, that miscegenation and laws that prevented Black and white people from marrying is what often keeps an ethnic group as a succinct ethnic group. Racism and discrimination against, say, people of color could perhaps keep whiteness as a kind of succinct identity. And so it is only really by kind of pressuring or forcing people who are part of different ethnic groups to only maintain romantic relationships, friendships, sexual relationships with their intergroup members that race exists and the ethnic group exists. So, unfortunately, what this perhaps means is that rape is why race exists. So, finally, I'll finish by discussing rape, intersectionality, and international laws. The problem from an intersectional feminist perspective is that without an understanding of intersectionality, we romanticize and celebrate ethnic identities without thinking of the ways that sexual violence, forced marriage, forced heterosexuality, heteronormativity are why ethnic groups exist and why they remain as pure entities, including a supposed white nation or white race, but also including every other ethnic group. And so this kind of celebratory rhetoric about multiculturalism then often involves refusing to think about the ways that gender-based violence and sexual violence creates a supposed ethnic group. Um, and similarly, if we think about women and only the rights of women as women, we then refuse to consider the ways that women who are part of certain ethnic groups are discriminated against or violated or abused as members of an ethnic group, who must constantly be pulled back to an ethnic group to reproduce a certain lineage. And in simple economic terms, this is really about capital, that one must remain loyal to a certain inheritance of people, a certain inheritance of names, a certain inheritance of language, a certain inheritance of religious texts. And if you do not want to use this inheritance in this way, then you could make money with and for other people. This is why a lot of countries and groups of people that have persistent problems with sexual violence and gender-based violence against heterosexual women also have problems decriminalizing gay rights, accepting gay marriage, and with transphobia and heteronormativity and uh, violence against queer people. The problems with the Gekambitsi case reveals that are revealed are not just about the limits of law in addressing the complexity of social ills like violence against women. Rather, Gekambitsi is important in demonstrating how, in this case, legal decisions presume rather than interrogate the processes by which conflict is deemed to be ethnic and violence becomes sexual. The Rwanda Tribunal offers a narrative in which sexual violence is depicted as almost the inevitable outcome of ethnic conflict, rather than considering the mechanisms by which a genocide might be enacted through particular modalities of violence and particular types of sexual violence. So, in order to remain genocidal, is it possible that sexual violence and is necessary? Yes, The problem is with this thinking is we can think about sexual violence and being sympathetic to an ethnic community where sexual violence is being used against their women. But could we think further and could we actually perhaps consider that genocide is only possible because their women remain their women and there is no necessarily fluidity. People cannot marry who they want. And ultimately, the queer or trans critique would consider the ways that sex and sexuality is constantly mobilized to support the existence of ethnic communities that are pure and remain at a distance from each other. And so, in order for this kind of genocidal thinking to remain to become irrelevant, this kind of purity, the existence of even an ethnic group that could say it remains as an ethnic group, would have to be, I guess, challenged by the existence of free people. So, Buss writes first, a more nuanced approach to genocide that challenges the inevitability of certain forms of violence allows for a sustained consideration of the structural dimensions of everyday life that form the basis for violent confrontation. Mass sexual violence is not a feature of all conflicts, and we need to question why and in what circumstances violence takes certain forms. Second, challenging the inevitability of sexual violence opens up consideration for the work and certain narratives of sexual violence do, including legal narratives and justifying forms of international governance. And finally, exploring rather than presuming the operation of identity categories like ethnicity may avoid the problem of legal decisions reproducing the narratives of ethnic conflict used and orchestrated by the perpetrators themselves. So Buss further writes, in my reading of Gakambitsi, I argue that a major difficulty in the tribunal's reasoning is its failure to consider sexual violence as part of the process by which ethnic identities are constituted. That is, in characterizing the conflict as interethnic, the tribunal shifts the focus to ethnicities as established entities rather than exploring the processes, including sexual violence, by which identities resonate and cohere at particular times and circumstances. So there is a complexity that is lost then when we refuse to consider sexual violence in the context of war as being intersectional in nature. The tribunals begin from the premise that these ethnic communities actually exist. And race, as many critical race theorists have argued, is a social construct. Without these practices of caste and class and ethnic endogamy, which, or endogamy, I think is how you pronounce it, which means that people marry and have children only within their ethnic group, and that people are punished when they have sex with or try to marry outside of their ethnic group. Heterosexuality is often also presumed to be the norm. And therefore, even the existence of these succinct ethnic groups, whom we can speak of as existing, is perhaps only a result of coercion, of child abuse, and of rape. And all of this processes of coercion, child abuse, and rape is obviously solidified by money. So if one decides to be queer, they might not receive support from their family. If someone decides to marry someone outside of their caste or class or from an ethnic group that their parents deem to be lesser than them, they could receive no financial support. Part of the reason the tribunal does this is because of the legal requirements of a crime against humanity outlined earlier, that the individual criminal act, here rape, must be shown to be part of a larger attack, the targeting of Tutsi civilians. In this case, the tribunal is recognizing that rape occurs in in the Rusumo commune, that it included the rape of Hutu women, and that taken together, these rapes were part of the larger attack against the Tutsi population. In a strict legal reading, then, the tribunal's characterization of Tie's rape as a crime against her husband may not appear that strange. However, this legal maneuver, placed in the context of the decision as a whole, is disturbing. So, uh, what Buss's article could ask one to do further research about or consider are rapes against transgender people, lesbians, divorced women, um, women with disabilities who are not married, two men who are leaders of a tribe. In this case, the tribunal is recognizing that rape occurred in Rasumo commune. Um, I think I said this already. How does violence against women and representations of violence against women enable a particular understanding of conflicts, their causes, and consequences? And how do those understandings in turn enable particular forms of law and legal intervention? And there are many different forms of legal intervention that can be taken. Firstly, I think it's interesting to think that the feminist movement, who is involved in advocating for the rights of women and the rights of rape survivors and survivors of child abuse in context of ethnic conflict, could consider the rights of transgender women and queer people, and whether or not the sexual violence and the kind of damage done to these people's minds, their capacity to earn an independent income, their capacity to get an education is taken seriously, or whether these crimes are thought of as in relation to the crimes of a husband or a father and the damage that is done to his family and his caste and his clan because of rape. Secondly, I think that law must also consider how an ethnic community is really formed and how a certain ethnic community or caste or class of people can remain pure or can call itself pure over generations. And is this done because of forced marriage, because of bullying and threatening of children who are not allowed to form friendships or romantic relationships with others? Is race really solidified through rape and through coercion? So finally, I will finish with this quote by Kimberly Williams Crenshaw. The way we imagine discrimination or disempowerment often is more complicated for people who are subjected to multiple forms of exclusion. The good news is that intersectionality provides us a way to see it. Kimberly Williams Crenshaw. So that is the lecture for this week. I hope that you are enjoying the class thus far. There are assignments and tests coming up, so I hope that you are finding time to do this work and also to enjoy the lectures. And I hope that you are enjoying the semester thus far. Thank you very much for your participation in the class. I hope that you have found the class enjoyable. And there are many ways to read Doris Buss's really rich and nuanced argument regarding intersectionality in the context of war. Firstly, one can consider the ways that responsibility in cases of wartime rape is understood. So, if tribunals understand that the crime against a woman who is part of a certain ethnic tribe is actually a crime against her tribe, her husband's honor, her family's honor, then it- do we understand her body and her experience of bodily violence to actually be a crime against her personhood? What if this woman was actually obviously like the obvious question that comes like to mind when thinking about feminist jurisprudence is the possibility that this woman could be raped by members of her own community, her own tribe, and would this be taken seriously? Um, the second question that arises, I guess, is about speech and about speech acts. Who speaks for whom? So, in the global war on terror, there have been many instances where gender-centric feminists have spoken on behalf of women who are imagined to be victims of religious violence by men. And debates regarding veiling and headscarves throughout the world have been central to this gender-centric analysis. But it has been women who speak on behalf of other women for their own class interests. So this is what happens when intersectionality is really not taken seriously. That women, the kind of lives that women lead, the experiences that they have, their marriage practices are judged only in relation to, say, a white middle class secular woman's life in North America. And similarly, when people think about ethnic violence, they think about ethnic violence against men. So intersectionality would allow us to think about who speaks for whom. Is it possible that when women in ethnic conflicts are victims of crimes, someone is speaking on their behalf. Western feminists and men who are leaders of tribes. And so, what is lost in this translation? We have discussed standpoint epistemology, and we've talked about the work of Sandra Harding, who argues that we must locate ourselves in a certain positionality. So, my position as a secular feminist and woman of color who's born and raised in North America, who has parents who are immigrants from India and international students, is a specific position. And it is a position that causes me to read this article in a certain way. And I read it as someone who does not believe that race is real and who does believe that ideas of ethnic purity often involve uh, refusals to understand an independent person's right to have relationships outside of an ethnic or religious group, including the right to be queer or trans. I also understand that this right to be an independent, autonomous person is the right to make money and to spend financial capital as one wishes to do. And this is my understanding and my reading of this article as a secular person. And so finally, I think that Doris Buss's article is really important in considering the idea of honor and the ways that honor-based violence can be used to kind of understand sexual violence as one more way in which an ethnic community is insulted or abused during context of war. And sexual violence could be understood from a medical perspective as violence against someone's actual body, rather than as symbolic violence. So those are my thoughts, and I hope that you are doing well. Thank you. Bye bye.